Hello, we are still in the season which in the justice sector of Nigeria we call the new legal year. And we're going to make ample use of this season by featuring as many courts as possible that are celebrating their new legal year. Welcome to The Scale. I am Femi Okeowo with the pleasure of having you with us on this edition.
Imagine any society without laws. Imagine piles of laws without the courts to interpret them. Imagine lots of interpretation without a medium to bring them to your doorsteps. The Scale, on the network service of the Nigerian Television Authority, helps to fill the gaps and turns law and justice into a tangible instrument for national development. That is The Scale, and it is balance.
We are starting today's edition of The Scale by visiting the FCT judiciary. The FCT High Court had its new legal year celebrated a few days ago. And like I had always enumerated, the new legal year is not just another ceremony. It is a time for stock taking. It is a time for the judiciary to look back at the year that has just passed and then project into the coming year. The coming year this time, 2023. We're just ending the 2022 new legal year and going into the 2023 legal year. And of course, you know, anytime you hear 2023 in Nigeria now, one thing that strikes you first is the upcoming general elections. And so all courts that mark their new legal year would be focusing on how they would impact positively on the general elections in 2023, another way of determining where our democracy goes. So let's go to the FCT High Court Maitama, where Justice Hussein Baba Yusuf marked his first new legal year. Not his first year on the seat, but his first new legal year. Join us as Aliu Chuku is our guide.
The 2022-2023 new legal year of the FCT High Court commenced with a series of events. Among is the inspection of the Guard of Honor by the Chief Judge of the Court, Justice Hussein Baba Yusuf. After the display by the Nigerian police force, judges and guests took their seats, and the business of the day started with honoring FCT judiciary staff who perform well in discharging their duties. After the ceremony, members of the bench and bar moved to the ceremonial court for a session while reiterating the commitment of the court to meeting the expectations of modern-day administration of justice and rule of law. The Chief Judge highlighted some of the challenges and measures put in place to meet up with the increasing demands of justice seekers.
Timeliness will be our top priority, and efficiency will also become the norm in the administration of courts. We shall work towards bringing about a change in the work culture and promote a new mindset. Steps will be taken to ensure that hearings of cases start on time and the number of adjournments in the course of a trial is reduced. Active case management is also practiced, and timeliness for the delivery of judgment are met. These are some of the ways that I believe an efficient and effective judicial system that is necessary to promote a sustainable environment of economic and social stability and the rule of law, in which other development initiatives, including poverty reduction, education, and gender equality, can flourish. In the pursuit of efficiency, we shall seek to find the right balance to maintain public trust and confidence in the administration of justice.
The Attorney General of the Federation and FCT Minister commended the judiciary and reiterated the administration's commitment to promoting rule of law that will enhance speedy dispensation of justice, not only in the FCT but across the country.
With a total of 16 judicial divisions, you will agree with him that what we have as the High Court of the FCT today is in fact a template of a strong, well-respected and highly professional institution that upholds the rule of law, serve the public and safeguard the interests of FCT.
With the symbiotic relationship between the bar and the bench, the two bodies pledge to work together to ensure that justice is delivered without fear or favor.
One of the ways in which justice can be done and also seem to be done is that judgments be made readily available upon delivery. He speaks from his experience across the country, but again he singles out the FCT for commendation for prompt delivery of judgments and making judgments available. For justice must be done and seem to be done. For people to see that justice is done, they need to have access to the reports, to the judgments, and speedily so. The President also commends the judiciary, the FCT judiciary, for making records of proceedings available very, very readily upon judgments.
There's no special role for the judges and their family. In these unending challenges of insecurity, kidnapping, banditry, the fall of the naira, the collapse of the electricity agency, the burning of diesel if you must submit your report, the cost of diesel has now snowballed, inability to visit ones, loved ones, and family, even if they were as close in Zuba or Kefi. If the horrible and unpassable road is willing, but the bandit will not allow. This is why we salute your Lordship, especially those who, despite these challenges, have the unwritten code to sit and do the needful, particularly those who adhere to the city time of 9 o'clock or so soon thereafter, and have stuck to the 9 a.m. and have been gracious and benevolent enough, whenever not practicable to sit at 9, to send apologies to the waiting counsel in court. We salute you. The body also salute you and do not be weary in this well doing, as you will surely reap the fruit if you faint not. For those who interpreted so soon thereafter to mean no tangible agreed time, or the soon indicate 11 a.m. or that 1 p.m. Others have interpreted it to mean keeping the counsel in court for hours without any word. This minority percentage will plead with you for a change of heart.
As the new legal year commences, effective service delivery is the key word. Aliu Tukur.
We have always focused on judges having conferences and seminars, or indeed workshops, across Nigeria. One area we really have not specifically talked about is a conference for heads of courts. Of course, when judges hold their conferences, you would expect that heads of court will be part of them. But then this time around, a specific conference has been held for heads of court. And when I heard that, I was excited because heads of courts really need to come together and streamline activities. It is the heads of courts that assign cases to their judges. And so when they sit together, I'm sure they will be talking about common interests and the way the law helps them to perform properly. So Olabode Arewa was at the National Judicial Institute where heads of courts of Nigerian judiciary had a conference.
It is electioneering time once again, and practically all sectors of the country are gearing up to take active roles in the activities. The judiciary sector is not left out as it strategizes to ensure that the autonomy granted to it by Section 17, 81, and 121 of the Constitution of the Federal Republic of Nigeria 1999 as amended remains sacrosanct.
The theme of this year's roundtable towards achieving better service delivery is apt, as the theme speaks to further strengthening of the judicial structure in Nigeria and the promotion of better service delivery in our courts. The actualization of this goal will aptly satisfy the demands of any democratic society in terms of eliminating delays in justice delivery and the elevation of accountability and transparency in the management of judicial resources. This will no doubt improve the overall efficiency in the administration of justice. My lords, judicial independence is critical to survival of any democracy, more so in a relatively young democracy such as ours. However, this cannot be said of many state judiciaries, as many of the heads of courts still go cap in hand to the executive for funds allocated to the judiciary, as against the provisions of Section 121, subsection 3 of the 99 Constitution. As we all know, this section, particularly subsection 3, says any amount standing to the credit of the judiciary in the consolidated revenue fund of each state shall be paid directly to the heads of courts concerned. That is the constitutional provision on the allocation of funds from consolidated fund. It is on this premise that I will urge all the distinguished participants to be proactive and bring to front burner the means through which we can advance independence of the judiciary to better improve service delivery in our courts, which is also vital in safeguarding the freedom and rights of citizens. Consequently, it is imperative for us to put structures in place that will enhance courts management and further strengthen strict judicial performance evaluation, while simultaneously addressing other concerns relating to independence of the Nigerian judiciary.
My Lord, there is no gainsaying that the fact that the transparency and accountability are two indispensable qualities of any judiciary in the world, as they aid in the fight against corruption and eliminate arbitrariness. In the light of foregoing, I make bold to say that fostering transparency and accountability at all levels of judiciary will not only increase trust but also strengthen the independence of the judiciary. Your Lordship, it is worthy to mention at this point that There is need to deepen cooperation between your lordship as heads of courts and your brother justice for ultimate productivity. Being the best among the equals, you should endeavor to cultivate a complete relationship with other judicial officers based on mutual respect and comradeship. And this will promote synergy and ultimately impact positively to the administration of justice. My Lord, the immunity of challenges faced by the heads of court and court administration, most especially at the state level, cannot be underestimated, some of which emanate from the inadequate structural facilities, lack of skilled manpower, inadequate information and communication technology facilities, all of which stem from inadequate funding of the court system and brazen disregard for constitutional provision. While recognizing that these challenges exist, they are not unsurmountable. It is hoped that this forum will afford the participants the opportunity to provide creative ways of tackling them and forging ahead. Let me state at this point that topic bordering on accountability and transparency in management of judicial resources, financial planning and budgetary preparation for judiciary, and judicial response shall be discussed at this forum.
In light of what some people with clouded intentions may want to use the judiciary to achieve, the Roundtable is also working to ensure that judicial decisions promote equal access to justice. In Abuja, Olabodarewa.
And finally on the program, we take a look at one area which we have in the past talked about. On the scale, we are particularly concerned about why non-custodial sentences are not being applied by our judges. Once upon a time, we all complained that the law does not provide for it. Now, the Administration of Criminal Justice Act provides specifically for non-custodial sentences. And one time I can say that this law was applied maximally was during the COVID lockdown, when people violated the lockdown and they were sentenced to non-custodial, using non-custodial provisions. Since then, I have not really seen non-custodial sentences being applied. It worries us that every sentencing is done in terms of sending people to jail, and that is not good for our society. And so we decided to talk to Professor Akinseye George, who has been part of the people who has canvassed for this and indeed had it inserted in the Administration of Criminal Justice Act. We talk about this and a few other provisions of the Administration of Criminal Justice Act. What are the alternatives provided to custodial sentences as provided for in the Administration of Criminal Justice Act as amended?
Thank you. Some of the alternatives to custodial sentences include community service. And that entails that convicts who are sentenced to community service will not go to prison, or to the correctional facility, but they will serve their sentence by providing service to the community. It could be in a hospital, it can be in a public school, it can be in a market, sweeping markets, cleaning government office, cleaning even the courtroom, So that's one, community service. And I'm aware that community service orders have been issued by courts, especially in the Federal Capital Territory and Lagos State. Several courts have issued community service orders. A second one is suspended sentence. Suspended sentence means that after the conviction of the suspect, he's not sentenced, but given time to turn a new leaf, maybe given 6 months
or 3 months or even 1 year. So if he behaves well during this period, he will never be sentenced. That's what is called suspended sentence. In other words, he's given an opportunity to turn a new leaf. There's also what is called rehabilitation. There's rehabilitation order. There is treatment. There are some convicts who do not need punishment in the real sense of the word. What they need is treatment. So the court can sentence them to treatment. In the government hospital, first of all, there will be an evaluation. And then they are made to go through a mental home because of the state of their mind. So such people are not to be sentenced to prison. There's also probation. Probation. This is to be administered in conjunction with correctional services officials. Somebody who is sentenced to probation is also expected to be of good behavior over a period of time under supervision. If he maintains that good behavior.
So it means he would be in custody?
No, he will not be in custody.
In his house?
He's under observation. He lives in his house, but it's under observation. It's under observation, and under supervision.
Yes.
And then he's expected to report at some locations at specified intervals. Maybe every week, every other week, or every month, but it's monitored. And in fact, in some advanced jurisdictions now, there is electronic monitoring. You plant a chip on the person.
Yes.
And you say, especially people who commit some offenses, like sexual offenses.
Yes.
You say, don't go to this vicinity.
Yes.
And if they go beyond that vicinity, don't go beyond this vicinity. And if they do that, the chief will send a message to the supervisor that your parolee, the convict has violated the terms of his sentence. So we have a couple of these alternatives under the Administration of Criminal Justice Act.
The Administration of Criminal Justice Act makes provision for an Administration of Criminal Justice Act monitoring committee.
That's right.
What is the job of that monitoring committee then?
The monitoring committee has a lot of functions. Their function is to provide synergy amongst the different bodies that operate criminal justice.
Okay.
The system is a system.
Not to monitor convicts.
No, that's not their job.
That's not.
That's not their job.
Okay.
But they monitor the work of how each agency connects with the next.
Okay.
The correctional system,
the police,
okay. The courts, the witnesses.
Okay.
And then how they exit the system.
Okay.
That flow.
Yes.
Does it go smoothly? If it doesn't go smoothly, Administration of Criminal Justice Monitoring Committee will say, no, police, you are not doing this job right. You are not doing this right.
Yes.
For correctional facilities, you are not bringing the suspects to court so that they can have their trial.
Okay.
So their job is to monitor this operation of the system to ensure that the system is flowing smoothly.
Professor Yemi Akinseye George, Senior Advocate of Nigeria, there, talking to The Scale some time ago. Those are the issues that have come up this week. Of course, many more are rearing their heads to come up in the coming days, and the Scale will be on their tail as we bring them to you to illuminate the justice sector of Nigeria. Thank you for being part of today's program, and we shall be seeing you again in subsequent editions.